In this lecture, we'll discuss the three different main kinds of Supreme Court opinions: majority plurality opinions, concurring opinions, and dissenting opinions. But first, it's important to understand the difference between voting and joining. In each individual case, every justice is confronted with not one but two decisions. How will I vote, and which opinion will I join? The first decision confronting a justice is how to vote, which simply means which side should win the case. But the more important decision is which opinion to join, because the opinion explains why that person won the case. Why is this important? Well, every Supreme Court case involves two parties, and of course they're very interested in who wins. But the more important thing is the legal reasoning that the court adopts to make its decision, because that can serve as precedent for future cases. And it simply takes a majority vote to win the case. So casting a vote decides who's going to win the case. That's not very important. What's more important is why they won the case, and it takes a majority opinion in order to establish precedent that can be used in later cases. And in order to establish precedent, a majority must not only vote the same way, but they must join the same opinion, meaning they must agree on the exact same legal reasoning. And if both of those things don't happen, then precedent is not established in the case. And in order to signal that a justice agrees with an opinion, they say that they join it. And so that is the difference between joining and voting. And so, if you are an author and you have been assigned an opinion, your goal, if you can do it, is to get at least 4 other justices to join your opinion. So that is your goal. Now, if you get that, you get a majority opinion and precedent is established. But if you can't get 4 other justices to join your opinion, then your side still wins, but precedent is not established, and it's not called a majority opinion, but rather it's called a plurality opinion. So plurality opinions do not set precedent. Majority opinions do set precedent. And every case has a main opinion. It's either going to be a majority opinion or a plurality opinion. The difference is whether or not one of them got 5 justices or not. So every Supreme Court decision has a majority or plurality opinion, but they may also be accompanied by one or more concurring opinions. Unlike majority opinions, concurrences are not assigned. Each justice gets to decide for him or herself whether they're going to write a concurrence. Concurrences are only written by justices who agree with the outcome of the case. In other words, they voted with the majority. Now, some justices who write concurring opinions may also join the majority opinion as well. That's entirely possible, but some justices will vote with the majority but will not join the majority opinion and will write their own concurrence. And those two situations are very different, so let's talk about what those two things mean. So first, let's consider the situation when a justice votes to join the majority but also writes their own concurrence. What does that mean? Well, that means they endorse the majority opinion, they agree with the majority's reasoning, and their vote counts as a vote toward establishing precedent, but they just want to say something additional. They don't disagree with anything the majority has said, they simply want to say something extra that the majority hasn't said. A classic example of this occurred in the Supreme Court case of Clinton v. Jones. In this case, Paula Jones had sued President Bill Clinton for sexual harassment, and the issue was whether or not this lawsuit could go forward while Clinton was president. Clinton had argued that the lawsuit should be delayed until he was no longer president. In the decision, the Supreme Court rejected Clinton's argument by a unanimous 9-0 vote, saying the lawsuit should go forward. Stephen Breyer agreed, and he joined the majority opinion. However, he also wrote a concurrence in which he said that he was worried that this decision might lead to a flood of lawsuits against future presidents, and that if that happened, perhaps the Supreme Court should go back and reconsider its decision. He was not disagreeing with the majority's decision. He wasn't disagreeing with the majority's reasoning. He simply had something extra that he wanted to say. But sometimes justices will write concurrences when they don't join the majority opinion. What does that mean? Well, that means they agree with the outcome of the case, but they don't agree with the reasoning of the case. And this is really important because if they don't join the opinion, then their vote doesn't count toward the 5 votes that they need in order to establish precedent. Now, a classic example of this kind of occurrence happened in Lawrence v. Texas in 2003. In Lawrence v. Texas, the state of Texas had a law that made homosexual sodomy, that is, oral or anal sex between 2 individuals of the same gender, illegal. And yet, oral or anal sex between individuals of opposite genders was permitted. And the question here was whether or not this law violated the Constitution. Ultimately, the Supreme Court ruled that it did. By a 6-3 vote, they struck this law down, and in fact, they overturned the court's decision in Bowers v. Hardwick that we talked about in a previous lecture. The reason that we're talking about it here, though, is that the 6 justices in the majority in this case had different ideas about why this law was unconstitutional. 5 of the justices thought that the law violated the constitutional right to privacy. And this meant that any law that made it illegal to engage in oral or anal sex between any 2 people would be unconstitutional. But there was one justice who agreed that the law was unconstitutional, but simply disagreed with why it was unconstitutional. Justice Sandra Day O'Connor argued that the law was unconstitutional not because it violated the constitutional right to privacy. She did not think it violated the right to privacy, but rather she said it violated the right to equal protection in that it made some sodomy illegal, that is, sodomy between 2 individuals of the same gender, whereas sodomy of 2 individuals of different genders was legal. And so, all 6 justices agreed that this law was unconstitutional. They simply had different theories about why it was unconstitutional. Now, it's important to note, in this case, precedent was set, nevertheless, because 5 of the 9 justices agreed on the same legal theory. And so Lawrence v. Texas made all anti-sodomy laws in the United States unconstitutional. Of course, there were 3 justices on the court who felt that this law was constitutional. Now let's consider dissenting opinions. Dissenting opinions, of course, are written by justices who are on the losing side, and they explain why they think the majority got it wrong. Now, dissents are kind of unusual because they take the same amount of time and effort as writing a majority opinion, and yet they have no value as precedent whatsoever. So a question might be, why does a justice write a dissent? Well, some dissents can be extremely persuasive, and in fact, some of the most memorable opinions in all of Supreme Court history have been dissents. And dissents are written because the justices hope to be planting a seed for the eventual overruling of the decision that they think the court got so wrong. It may take 10, 20 or years or longer. The justice may not even live long enough to see their dissent become a majority opinion, but nevertheless they are planting a stake in the ground and they are waging battle. Just want to highlight a couple of the greatest dissents in American history, and there have been some justices who've been known as great dissenters, and one of those was John Marshall Harlan, who dissented in many cases, but one of these was in Plessy v. Ferguson in 1896. Plessy v. Ferguson, of course, was the case in which the Supreme Court decided that it was constitutional to allow segregation by race, and this was a near unanimous decision. John Harlan was the only one who dissented, and he wrote one of the most famous opinions in all of Supreme Court history. In view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights, as guaranteed by the supreme law of the land, are involved. The Supreme Court eventually adopted that logic in Brown v. Board of Education in 1954. Another very famous dissent, and great dissents often peer into the future, and this one definitely did. Louis Brandeis dissented in the case of Olmsted v. U.S. In Olmsted, the issue was whether the police were required to get a search warrant before they could place a wiretap on somebody's phone. This was in 1928, and phones were relatively new, and the police suspected Olmsted of engaging in criminal activity, and they placed a wiretap on the telephone box outside of his house, on a telephone pole near his house, but not on his property, and they listened into his conversations, and they never obtained a search warrant. After he was convicted, Olmsted sued and said that under the Fourth Amendment they should be required to get a warrant. The Supreme Court disagreed, saying that the Fourth Amendment only applied to tangible objects, things that could be touched and taken away, things like papers or cars or objects, and that in this case the police were merely listening in to electronic impulses, and therefore they were not required to get a search warrant. Louis Brandeis was the only dissenter in this case, who of course pointed out the fact that the framers could not possibly have anticipated electronic eavesdropping because that hadn't been invented when they wrote the Constitution. And in writing his dissent, he planted the seeds for what later became known as the right to privacy. The protection guaranteed by the Fourth Amendment is much broader in scope. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred as against the government the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. Again, he didn't use the term the right to privacy, but this is the beginning of the evolution toward the court's adoption of the right of privacy some 40 years later in the 1960s. So why do these justices write dissent? Well, as already indicated, they are hopefully planting a seed for the future, and obviously both of the dissents that we just discussed were vindicated over time and are now accepted law. But, of course, justices are human, and so one of the purposes of a dissent is simply to vent when you feel the other side is wrong. Very few people want to remain quiet about it, and justices certainly don't, and so they simply want to get something off of their chests. And, of course, a dissent also is a signal to the losing side. It's a form of consolation to let them know that, hey, somebody heard you. You weren't speaking into the void. Somebody agreed with you. Whether that's a consolation or not, I don't know. And, of course, one of the most important purposes of a dissent is that it forces the majority to sharpen its reasoning. And this is one of the things I love about the Supreme Court, is that the majority opinion and the dissenting opinion confront each other. They discuss each other's arguments, they talk about why they're wrong, and so each one forces the other to make a better argument. And this process of argument, dissent, majority opinion, hopefully over time creates a higher level and higher quality of Supreme Court opinion. And sometimes dissents can try to give Congress or the lower courts guidance on how to evade the ruling. And in fact, as you'll see as you read the oath later on in the semester, Ruth Bader Ginsburg did exactly this in the Lilly Ledbetter case. So I won't talk about that right now, but when we talk about the oath and when you read the oath, make sure to pay attention to what Ruth Bader Ginsburg did with regard to Lilly Ledbetter. Now, we have talked about the three main kinds of opinions, but there is one additional kind of opinion which comes up. It's not very important. These are known as per curiam opinions. Per curiam opinions are merely short, unsigned opinions. The main thing about a per curiam is that they're unsigned. They typically don't set precedent. They're used in a variety of situations. But nevertheless, there is that, so just wanted to mention that those do exist. Now, also wanted to mention that we've talked about the three main kinds of opinions, and that justices can join or not join opinions. But in fact, justices have the option of joining parts of opinions, but dissenting from other parts of opinions. In other words, justices can concur in part and they can dissent in part. And this can be very confusing because each one of the 9 justices, except for the one who's writing the majority opinion, all of them can concur in part and dissent in part, and they can concur in different parts of opinions and they can dissent in different parts of opinions. And most of the time, things are pretty straightforward, but sometimes it can make for very confusing opinions. And it's important because remember that precedent is only set when a particular opinion has 5 votes. And so sometimes it can be very hard to tell what part of the opinion got 5 votes and what part of the opinion didn't get 5 votes. So what part is precedent and what part isn't? Now, just to give you an example of how confusing things can get, this is the Obamacare case that you're reading about in the Oath, National Federation of Independent Business v. Sebelius from 2012. And here you can see the way the vote broke down in that case. Roberts announced the judgment of the court and delivered the opinion of the court with respect to parts 1, 2, and 3C, in which Ginsburg, Breyer, Sotomayor, and Kagan joined, an opinion with respect to part 4, in which Breyer and Kagan joined, and an opinion with respect to parts 3A, 3B, and 3D. Ginsburg filed an opinion concurring in part, concurring in the judgment in part, and dissenting in part, in which Sotomayor joined, and in which Breyer and Kagan joined as to parts 1, 2, 3, and 4. Scalia, Kennedy, Thomas, and Alito filed a dissenting opinion. Thomas filed a dissenting opinion. Wow! What does that all mean? Well, fortunately, although this is very confusing and various justices were all over the map, particularly on the liberal side, there's an easy trick that I'm going to share with you to determine what parts of an opinion are precedent and what parts are not. The parts of an opinion that are precedent are labeled the opinion of the court. So when you read the beginning of a Supreme Court opinion and it tells you how people voted, anything that says it is the opinion of the court is a majority opinion and it establishes precedent. If it's an opinion, then it is only a plurality opinion and it does not establish precedent. And so you can see, looking here, parts 1, 2, and 3C are the opinion of the court, and so those are precedent, and you can tell that there were 5 justices who joined those parts: Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. The rest of it is simply labeled an opinion, and therefore none of the rest of it is precedent. So that's how you interpret a Supreme Court decision. Now, just to show you how very confusing things can get. In 1972, the Supreme Court decided the case of Furman v. Georgia, which had the most opinions that are possible in any Supreme Court case. This was the case in which the Supreme Court decided that the death penalty was unconstitutional. Now, they reversed themselves 4 years later in 1976, but in 1972 they declared the death penalty was unconstitutional. This opinion divided the court sharply. Not only was the court sharply divided with a 5-4 vote, but the justices had great difficulty settling on one particular theory. And in fact, although there are only 9 justices, in Furman v. Georgia, there were 10 opinions. There was 1 per curiam opinion, 5 concurrences, and 4 dissents. Again, they were all over the map. This is the most opinions you can have, the most opinions there's ever been.